Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger for Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase RIC, of the capital M, lowercase ARTIN family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine. And here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it just standby?
Make my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. Well, that's I was going to make the motion to dismiss him if he's if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys who's going to fraudulently assume I'm a defendant, and which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
you got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man. So, as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent, and it's also under. There's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions though for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not. You know, there's no standing, shouldn't move forward. But they say you're going to be questioning me about the some demands that made to dismiss the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I made or sent to you already.
So
you're going to
first of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
Okay, I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons are not, or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable right, human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, you know, and that's backed up by law. And that's how I've been taught. And so that's what, you know, so it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm just.
So you're about to end of your 5 minutes.
Well, I objected 5 minutes being any time limit also. That
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to, none circular. I didn't finish the first time. All right, well, that's it. As to that,
Eric Martin walks in declaring he's a living man, not the defendant. The room freezes. It's that classic sovereign citizen moment where logic leaves the building. The judge tries to stay calm, but you can almost feel the disbelief behind her eyes. Eric thinks rejecting the court's language frees him, but all it does is bury him deeper. It's arrogance disguised as enlightenment, and the judge knows it.
oh, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I want that out.
As to your motion to recuse, that is denied.
Based on what reasons? Conflict of interest is my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed. That's the grounds of and I would like to Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, by, in this case, writing the tickets, and I request you prosecute them for this, because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance. So I was all within my right under that federal statute that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions here specifically, and I'm going to mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. So as they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stopped and wrote a ticket. None of that. So I'm the crime victim. I request you prosecute him for that. And it's also federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back. So yes.
Anything else, Mr. Martin?
Eric actually tells the judge he's suing her, in her own courtroom. You can hear the oxygen leave the room. It's bold, but it's also hopeless. He claims the court is corrupt, yet keeps begging it to listen. That contradiction is the heartbeat of every sovereign citizen case, rebellion without understanding.
He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, For my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other two. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from versus Doan's Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows that does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washington. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. The manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal, or even a federal lawsuit, does not insulate you from the contempt powers of that very same court, should you choose to continue escalating that type of behavior. That's just the more you know from me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case I guess, in his mind and on paper, it doesn't mean that that exists in reality. So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply today. The last two things that were filed before the court are two demands. The court has already mentioned demands.
Then comes the quiet execution. The prosecutor doesn't raise her voice, she just dismantles him, line by line. Real statutes versus fake internet quotes. Calm precision versus chaos. You can almost see Eric's confidence evaporate as his truth collapses under real law.
Okay.
That's not how this is gonna work, sir.
That's
I
not
think
how
to understand here, you
I have the right to that. What are you talking
you're
about?
not controlling this courtroom, sir. That's not how this works.
As I'm speaking about what I have a right to do, I have a right to respond back. So
You're
All
gonna
right.
get 5 minutes and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got
So-
5 minutes. I'm actually setting a timer.
all right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes. Now please move forward.
Criminal. Okay, I want to object to that too, though, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
As to the criminal complaints, in response to what you said about that MCR, the refusal to act on my criminal complaints that I filed because of MCR 6.101. And now, first of all, it violated my due process right, obviously, because they didn't mention a subdivision, a subsection of that rule. There's many subsections. Okay. So I'm still left in the dark on what specific subsection it is. And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. Okay, if it is for that reason, those reasons are unconstitutional and therefore it's invalid. That court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there because it's not legit. Why it's not legit? Because as I cited in there, I'm pretty sure I cited in there. If I didn't, I have to check my paperwork. But I'm pretty sure I cited in there, or I was waiting to respond back if I didn't already. But I'm gonna say right now that it violates the court rule on, not the court rule, the Michigan Constitution part that says, but I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one, in the very first one, because I didn't know, what the hell subsection it was talking about. They didn't mention it, but I know I mentioned in some later ones sent to you guys. But anyway, so yeah. So it violates that right. And also the US Supreme Court case Murdoch versus Pennsylvania. And I got the volume number, page and all that. I think I said to you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money for something. A right's a right. Bringing something to the court's a right, be heard is a right. I don't have to pay money for that. Criminal or civil case. Okay, so it violates due process. So all that's legitimate. They're illegitimate, that is, their arguments are using for that. It's supposed to be acted on regardless of a prosecutor's approval or not. Okay, anyways, now as to her asking who's Mike, he's the manager at Area Towing. But she would have read it. It was in that document to explain that. So, okay. Anyways, as to the Penhollow, what she said about the quote about the Penhollow case. Okay. Now, first, I want to say, regardless of the Penhollow case, what she said, The Declaration of Independence of 1776 makes it clear the government has no power over the people. They derive their power from the consent of the governed anyways. That's something that's clear right in there. Okay. The consent of the governed. I never consented and never will. I didn't have enough time to go over the Penhollow case, but if I remember it, I was just in the law school law library recently trying to verify that quote, because a lot of these quotes that I got, that I'm citing in the court, some of them I have read and some of them I haven't. This Penhollow case, I'm not sure on that. I admit that. I have to double check myself because a lot of these I get online, YouTube, and a lot of them have been shown up to be legit because I go to law library and I double check on them, the quotes. In the Penhollow case, if I vaguely remember, I think I did have a problem myself finding that quote, saying that exactly like that, but that's not saying it doesn't stand for that proposition. I'm sure it still does. I just got to go back to the law library and read it again. If I did read it, I kind of don't remember because I got a lot of stuff I'm doing. But yeah. So bottom line, I gotta check up on that case. So it'd be premature to rule on it yet, as to whether that Penhollow case is illegitimate to stand for that proposition. But I know U.S. Supreme Court cases still say it because it's all based off the Declaration of Independence, so there should be no doubt on that. And U.S. Supreme Court cases exist that say that Declaration of Independence is part of federal law, United States Supreme Court law, and it's the basis of the Constitution, so it's legit.
Finally, the judge loses patience. After endless interruptions, she reclaims the room, sharp, firm, done playing nice. Eric shouts about First Amendment rights, but it's over. His fantasy of freedom ends where the law begins. The real authority isn't in his words, it's in her gavel.